This PowerPoint is part of a course on collective management aimed at policymakers. In a collective management system, owners of rights authorize collective management organizations to manage their rights. The shorthand CMO comes from the initials of a collective management organization. Collective management organizations are usually not-for-profit organizations, even though for-profit organizations also exist. The majority are private organizations run and governed by rights holders. In some countries there exist governmental or semi-governmental organizations. A crucial question is, can there be only one organization per rights holder group or right at a given time, or is it possible to have several competing CMOs? Some CMOs manage a single repertoire, for instance musical works. Some others are so-called multi-purpose organizations representing all genres of work. The type of right that CMO manages affects its legal framework. When a CMO manages exclusive rights of rights holders who have properly mandated the CMO to take care of their rights, we talk about voluntary collective licensing. Rights holders could manage their rights individually, but they have chosen to authorize a CMO to do that for them. In some cases, national legislation includes some form of support mechanism to make collective management easy for users and to eliminate the challenge of non-represented rights holders. In some cases, national laws only include a right to equitable remuneration instead of an exclusive right. And in those cases, management is non-voluntary. The rights holders cannot manage their rights individually. In the case of voluntary collective licensing, a license that a CMO can offer to users covers the works of the represented rights holders. This means that the CMO needs to acquire mandates from national rights holders and conclude agreements with similar foreign CMOs in order to get the representation rights from them. The rationale behind the consideration of some forms of legislative support mechanism is to eliminate the burden of non-representative rights holders who retain their exclusive rights and can prohibit the use of their works. A user who has acquired a license from a CMO would usually like to use the works of all rights holders, whether they are members of the CMO or not. There are different options that the legislator could consider to assist the CMO and to make the situation of the users fully covered. These options are the following: extended collective license, legal presumption, compulsory collective management. These are all designed to tackle the situation of non-represented rights holders. In a non-voluntary system, the consent of rights holders is not needed, but they have a right to equitable remuneration. The stipulation can be constructed as a compulsory license, meaning that the CMO and the user need to negotiate about the size of the remuneration. In the case of a statutory license, the size and the remuneration is set by statute. Both fall under the concept of non-voluntary licensing. The situation is the same with remuneration for private copying, a system where compensation is paid for large-scale private copying. First and foremost, the role of government lies in implementing a proper legislative framework and ensuring awareness of the existing laws. In some countries, the government has a direct role also in relation to collective management. The most customary task for a government is to authorize a new CMO before it can start its operations, and secondly, to supervise its ongoing activities. Next, let's look at authorization and supervision in more detail. An authorization can also be called an approval or a license in your national legislation. It is given at the initial stage before the operations of a CMO can begin. The most important task for the relevant authority is to examine if the applying CMO is sufficiently representative. Secondly, for how many years should the authorization be valid? The answer to the latter question is found in the legislation of the country, the usual period being from 3 to 5 years. In countries where the national law provides for supervision of ongoing activities, the authority usually examines issues related to tariffs and distributions. The CMO is obliged to provide the authority their annual reports and audited accounts, which are the major documents to be examined. In cases of serious doubt about irregularities, the authority may need to organise a special audit by an independent specialised company. It is likely that disagreements may occur during negotiations about tariffs and other conditions of a licence, in particular when the CMO is new on the marketplace and there is no reference point from earlier settlements. The question then arises, which is the proper forum for dispute settlements? In some countries, all disputes are settled in ordinary courts. In some others, there are special dispute settlement procedures and forums, such as mediation, arbitration, or copyright tribunal. In many cases, CMOs are in a legal or de facto monopoly position. This is particularly so if only one organisation is authorised at any given time to function as a CMO. Whereas a monopoly position is not illegal as such, abuse of such a position is not allowed. The stipulations of competition law may have relevance in 3 different relations in the work of a CMO. Relation between the CMO and its members, the relation between the CMO and users, and the relation between 2 CMOs in different countries. For a policymaker, it is important to understand the interrelation between competition legislation and stipulations concerning the supervision of CMOs, as these should be in harmony with each other. A CMO deducts its administrative costs for the gross collections and distributes the rest to rights holders. The national laws of some countries include an upper limit of administrative costs, for example 20 or 30% of gross collections. As to other deductions, some CMOs make a small deduction for social and/or for cultural purposes. If they do so also from the share of foreign CMOs, this needs to be negotiated in a reciprocal agreement between the 2 CMOs. A CMO has a set of tasks as a rights management specialist. These include monitoring the use of works. This is an obligation for users under a license. Negotiating with users. Tariffs are negotiated with users or the representative associations. Giving licenses. Usually a blanket license is offered, giving to the user the possibility to use any works of the repertoire of the CMO. Collecting fees quarterly, twice a year or at least once a year. Distributing fees to rights holders, which is the primary task for any CMO. In short, we can say the collective management means money in and money out.